Just introducing myself really briefly. Jo Sherman, EDT, what's an Australian doing talking about this topic? Just lucky, I guess. When you've got an accent that shows that you come from somewhere other than the US, you suddenly become presumed an authority on all things non-US. So I'm working with that. Anyway, my company is EDT. We're doing a bit of work in this area in terms of software, and I'm delighted to be here. I'm joined by an esteemed panel of privacy, eDiscovery and litigation rock stars, and this is a hot topic. It's going to be fun to hear their views and to discuss the many aspects of this whole debate. I'll start by just saying that on the 6th of October, the European Court of Justice handed down the decision of Schrems and the Data Privacy Commissioner. And whether you regard Max Schrems as a Gen Y troublemaker or a privacy hero or a self-righteous vigilante, the fact is this case has actually sent shockwaves through a lot of the internet community for sure, but also some of the boardrooms of multinational corporations because of the potential ramifications in terms of data transfers from the EU to the US. Now that touches on not only areas like eDiscovery and investigations, of course, but more broadly to business as usual operations involving data transfers. So today we're going to talk about the many aspects of this decision. I'd like to introduce my panellists, my colleagues, and we're not going to go through a very detailed intro because, as you can see, we have a number of panellists here, and we will take too long. So we have Mark Francis and David Cohen, my colleague who's just come over from the UK. Thank you for making the trip, Damien Murphy. Melinda McClellan and Patrick Burke. And if you're interested in their profiles, of course, it's all in the little booklet there. So I thought a good place to start might be actually, Mark, perhaps you might like to give us a little bit of background into what the Schrems decision is all about and what it means.
Sure, and just to provide a little bit of background, I'm sure many people here know where the safe harbor came from and why we are where we are. But just to provide a little more of a background, the Data Protection Directive is one of the fundamental governance bodies for privacy law in the EU. It went into effect in 1995, and it covers all European Union member states plus Iceland, Liechtenstein, and Norway, which collectively is the EEA. And it directs each member state to institute their own national laws that live up to the directive, and some states, in fact, have stricter laws in some respects. A number of non-EU countries were deemed to have adequate security protections in place for privacy. Countries like Canada, Israel, Switzerland were deemed adequate, and therefore data can be transferred out of the EU into those countries. However, the United States does not have any comprehensive privacy law or framework, and therefore there was a growing issue with transferring data into the US. The EC came to a decision in 2000 known as the Safe Harbor decision, and they allowed data to be transferred, EU residents' data to be transferred into the US under the terms of the decision, which were that the companies moving the data would have to register with the US Department of Commerce. They would have to self-certify compliance with the 7 key privacy principles of the EU Data Protection Directive. And just to mention them at a high level without getting into details, those are the notice, choice, onward transfer, security, data integrity, access, and enforcement. And these really are derived from the OECD principles that the Data Protection Directive is built on. Now, the Safe Harbor framework is extremely popular in the internet world. There are roughly 4,500 companies that are registered with the Department of Commerce for the Safe Harbor framework. And so in today's world, there's a tremendous amount of data moving back and forth based on the Safe Harbor framework. Following the Edward Snowden revelations in 2014, an Austrian privacy activist, Max Schrems, he's not up here anymore, he challenged the framework and he sued Facebook, which was one of the companies detailed in Snowden's disclosures. It was on the PowerPoints, and he accused Facebook of supporting or at least giving their data over to U.S. surveillance. And in view of that, he said that the privacy principles under the Data Protection Directive were not being maintained in the U.S. He sued them in Ireland, which is where Facebook's EU headquarters are based, and perhaps for that reason or other reasons, the Irish court was not inclined to let his case proceed. The court dismissed it. Max Schrems appealed to the High Court of Dublin, and they referred the case to the European Court of Justice, which is, in this respect, the Supreme Court in the EU for matters of this nature. On October 6th, as was mentioned, the European Court of Justice handed down a decision finding that the Safe Harbor decision of 2000 was invalid. And in their decision, they described that based on the surveillance apparatus in the United States, the manner in which bulk data is collected by the government, the Data Protection Directive's principles, those 7 principles, were not being upheld in the U.S. So the reaction to this, and I'm sure we will get into this, but the reaction to this has, of course, been very mixed. Businesses are in a bit of a panic, and many of us are getting phone calls from many companies trying to figure out what to do next, both in the short term and in the long term. With the U.S. government is obviously very concerned, and they're trying to balance their law enforcement and anti-terrorism activities with the increasing pressure in the U.S. and now especially in Europe to protect data privacy. And within the EU, in particular, I would mention just a couple of entities in the EU that have been speaking out about this. The Article 29 Working Party, which has a representative from every member state and is kind of the guiding body on data privacy issues, they came out with a statement after the decision. They said that they would give companies until the end of January 2016 as a grace period, in large part to see if the U.S. and the European Commission would be able to negotiate a Safe Harbor 2.0 or some other arrangement that could be used. And they also noted that companies could use other legal mechanisms available under the Data Protection Directive, including model contract clauses or binding corporate rules known as BCRs, and I think we're going to get into those. And they suggested that those other legal mechanisms would be available. However, in particular, there was a data protection authority in one of the German states that came out with a position paper, and they argued that under the logic and the reasoning of the ECJ decision, that all the data transferred into the U.S. Can be picked up by U.S. Authorities, the other legal mechanisms should fail on the same grounds. And so even though the Safe Harbor was the only mechanism officially declared invalid, they raised some serious questions about the other mechanisms, and companies are wondering if that is just a one-off opinion, or if that is going to carry the day with other data protection authorities throughout the EU.
So Mark, one of the things I have heard the binding corporate rules and the model contracts referred to as chocolate teapots. you know, when they are subjected to a bit of heat, they're going to sort of crumble or melt. And it's a good segue, I think, for Damien to give us a little perspective on, you know, from the across the pond, the EU perspective, Damien, on all of this.
And sort of with due deference to Mark, I wanted to just correct something that he said earlier on, because I think it's quite an important correction in terms of looking at what Schrems did. So Max Schrems has never sued anybody, right? Max Schrems made a complaint to the Irish Data Protection Commissioner. Okay, that's just something anyone can do. It's like it's something you can do in sort of 20 minutes. You send an email in, and in it goes. And in fact, he made 22 complaints to the Irish Data Protection Commissioner, all about Facebook and all about the fact that, notwithstanding that it is based in Ireland, the data is held in the US. And he made 22 complaints, and the Irish Data Protection Commissioner was sort of wading her way through those complaints, or his way at the time through those complaints. Then Edward Snowden went to the Guardian newspaper, the Washington Post, and the New York Times and released vast amounts of detail about the PRISM program in the US, which was really a program which it was asserted or alleged that there was indiscriminate surveillance of electronic communications by the National Security Agency. That triggered, from Schrems, a 23rd complaint to the Irish Data Protection Commissioner, who still was looking at the first 22. The 23rd one was, if what Snowden says is true, then you have to act, because you have to see that in fact my other 22 complaints don't really matter. We've now got clear evidence that there is inadequate protection of my fundamental human right to privacy, and that is as evidenced by the Snowden revelations. So what Schrems then had to do was basically argue it out in front of the Data Protection Commissioner, who said, well, look, I'm afraid there's safe harbour, so my hands are tied, right? Nothing really that Data Protection Commissioner could do, because safe harbour says, well, it's fine. And then Schrems he had no means to appeal that. He had to basically make what we call in the UK and Ireland an application for judicial review to say that that decision you've taken is so unreasonable that it makes no sense, right? And that's what went to the Irish High Court. I would really commend, and you can get it online, that the decision of the Irish High Court to look at, because it's the Irish High Court who contemplated it, realised, wow, this is big, went through it in sort of like really kind of refined detail, and said some very interesting things. Basically, it was, you know, if I ever meet that judge, I'm sort of predicting he's kind of pretty chilled out guy, sort of knows his stuff, because he just sort of went, well, look, surely everybody knows we're being our communications are being intercepted. It would be a credulous person who thought otherwise, and it's not just the US. He was also saying that, you know, the first people who complain about it may well themselves be intercepting, because it's all about what's in the national interest at that time. So I'd really commend that decision as a sort of as an analysis from a European perspective of how we look at privacy, because I think the history of privacy in Europe and the history of privacy in the US, you know, I mean, there was a turning point, I suppose, because I mean, if you think of privacy in the US, this dates back to, the US postal system, right, was set up 1 year before the Declaration of Independence. Why was it set up 1 year before the Declaration of Independence? Because people in the US felt that the Brits were intercepting their mails in order to work out who was doing bad things so that they could then track them down. The US Postal Service was a direct consequence of that, the Americans deciding that we want private mail, so we'll set up our own service. So it's always been a big thing in America, but I think the sort of history, the context, which I think is an important point, is why is it so big in Europe? Well, it's so big in Europe because really Germany is so big in Europe. And there is a kind of history within Germany, a sort of Stasi-based, I mean, this is how it's said. I mean, I've never asked any German, so I don't really know, but it's a sort of, I can see the logic of this, that within the sort of states, former communist states, other states that have had totalitarian regimes in charge, the idea of your data basically being made available such that decisions could be taken about your life sends a sort of shiver down the spine of in particular Central Eastern Europe, as to how important it is to protect my data. So I think that that's where we have a sort of, that is the context in which you need to look at these decisions. That Europe, driven largely by Germany, so let's say you go onto Street Map, right, in the UK, you can go and see my house, and it's like, you can look at it, you can't really see very much because I've got sort of a van parked beside it, but behind that is my house. You go to, say, my equivalent in Germany, there's a good likelihood that person would have blurred out their picture on Street View. So in Germany, the idea of a van driving around and taking pictures of everyone's house, you'll see there's gaps on all the streets because people have said, I don't want my house on there. You go to Germany, try and do a Skype call to a German. There's a good chance you'll find there's nothing there when you turn on the video because they tape over the actual camera on the laptops that they buy, not just in Germany. So it really is a real thing out there. It's less so in the UK. I mean, we are kind of, I would say, I think most people in the UK think of spies a bit like James Bond, like fundamentally quite a good guy. You know, we sort of trust him in the UK. We trust our spies. It's incredible. But I do think that there is that, whereas in other countries it's not the same. So I think that's
it's going to be interesting in France now, because after the Charlie Hebdo and what they went through over there, they basically passed, the Ultra French Patriot Act and, legitimized all kinds of things that evidently they had been doing for a long time. And the other great part is like our Patriot Act and another PRISM protects your data in the United States a lot more than it protects people around the world. So in a sense, if you bring your Facebook data to the United States, you maybe have more protection than you would if you kept it in Austria. But it will be interesting to see when the Edward Snowden of France, Edouard Snowden, comes and says, "Hey, France isn't safe." Now what are you going to do?
There's some new legislation, I think, too. Some surveillance legislation is just about to go through. Or Melinda could probably correct me on this. In the UK, it got a bit of attention in the last couple of days. There's some new UK or Damien.
So on the sorry, Belinda. So on the UK side, we've just had our Home Secretary put before the sort of the legislative process a new, what is known in the sort of left-wing liberal press as a snoopers charter. What within the sort of people who are slightly less concerned about data privacy is called something like the surveillance count, whatever it is, and it's had the idea being that, for example, your internet history will be maintained by ISPs for a year, as one of the examples. The idea being that, Robert Harris, so the author of Fatherland and various other kind of like just above beach reading type books, has said, imagine like if this was 40 years ago and the government said every library now needs to report to us every single book that anyone's ever taken out, every restaurant needs to tell us every single restaurant everyone's been to, every single shop needs to tell us every single thing we've ever done. Imagine how that would have looked 40 years ago. And the context has changed. We're in a less innocent age now. Sorry, I interrupted really.
No, not at all. There's a Cyber Information Security Sharing Act that passed the House in the United States, and it's supported by businesses because effectively it allows businesses to share different kinds of data, threat information, intelligence information, and shields them from liability for having shared that information. So the big tech giants have issued statements sort of opposing it, but a lot of businesses are in favor of it. And it's coming at the same time where we're trying to negotiate a new safe harbor agreement with the EU. It's
perhaps unfortunate timing.
Well, yes, and it's just so contradictory, but we do know that other countries also want to defend their homelands against potential terrorist threats and against cyber espionage, and it's not just terrorism in the 9/11 sense. I mean, it's all sorts of Chinese hacking, cyber espionage, and other things like that. And companies want to be able to share this data, but in some cases it's sharing personal information or individuals' data, and in mass quantities, and they would be shielded from being sued for having done that. And it's
sure. Patrick, from the perspective of the model contracts and binding corporate rules, which are often put up as alternative mechanisms to get data out of the EU, do you want to give us a little bit of a perspective on what you're doing in that area? And
in terms of I remember I used to work at a eDiscovery vendor, and there was tremendous pressure on us to get safe harbor certified, right? So that we could collect data over abroad and bring it over here and turn it over. And it was one of my key roles was to block that because it's inherently violative of safe harbor. I think the eDiscovery industry, that this is really lucky that this Facebook case with Schrems wasn't an eDiscovery company, because with Facebook it comes over the U.S. and then maybe American law enforcement pokes at it and it's not safe. But eDiscovery bring this data over, and we're pretty much guaranteeing we're going to deliver thousands and thousands of it to a third party litigators, right? And God knows what happens after that, right? And I mean, it should not be allowed to happen. If I was somehow hired as a DPA over in England, and they were like, what are we going to do about safe harbor? I'd say, let me at the eDiscovery industry, and we'll take this thing down in no time. So if there are those of you who use safe harbor on the eDiscovery side, put in a call to your lawyer, because
Stop.
It's totally pouring out the other end. So eDiscovery wise, we deserve every complaint against safe harbor that the Europeans have. So we should be ashamed of it if we use it that way. So there are ways to agree that you're gonna comply with EU rules, and you can use standard contracts. BCRs are when you do it on the basis of the entire entity, entire company. So your internal transfers, and then any transfers you have with the regular providers are all revealed to the administrators, the data authorities in Europe. I think my impression is, if you judge over the last couple of years, what have the EU data people been pushing? And one thing they're pushing is killing safe harbor, so that's kind of going the way it was. They weren't happy with it before Snowden, but BCRs, they were always sort of happy. It was the American side that was grumpy about BCRs, because it took too much work to do it, and you had to apply to you had to give a lot of information. Whereas safe harbor, you fill out a form with the Commerce Department, you're done. So I think BCRs, if you read like the ICO, which is the Data Protection Authority in England, it issued a post-Schrems, kind of calm down, we're on this. There's still BCRs, there's still standard clauses. They're both being looked at, but nothing crazy seems to be happening. There was supposed to be this concept that BCRs would be made easier, this one-stop shop where there'd be less bureaucracy. That, as far as I know, is still on track. Could all be blown up with this, but BCRs in terms of clients and companies, I think look promising. Standard clauses are looser, but they've got their role, and they may reinforce them on the European side. And safe harbor, I think it needed more accountability, but we have to stop using it in this industry. Unless you get consent. Consent's the best thing. If you get a data subject's consent, and we're in one of the few doable areas for that, because you have, maybe you have 20 custodians, maybe you have 200 custodians, but it is doable to get a consent or try really hard to do that kind of thing. And then, you could safe harbor it over and then consent it from there. But
I will say, though, in the European Union, sometimes in the employment context, they won't accept consent. Right. Because they consider it inherently coercive. So you can't say to your employee, do we have permission to transfer your data to the United States? And if you say no, you're gone. So,
but it's like the closest thing you got, so you do it.
It's an option, yes, but it's sometimes not accepted.
Yeah.
And Mark, I think you were going to say something about derogations and consent at some point too.
Yes, so there's actually, I think about 7 or so exceptions, or they're called derogations, that in addition to model contracts and BCRs, can be used for cross-border data transfers under Article 26. But For purposes of eDiscovery, for example, there are a couple that are most valuable, consent being probably the number one. And it's just a little bit of a different concept of consent. In the US, you may have a privacy policy that says at the bottom of the page in fine print, by visiting our website, you consent to us doing whatever we want. And sometimes that's okay in some contexts. But in the EU, consent has a very specific prescription to it. So it has to be very clear. They have to know what they're consenting to. In other words, what data they're consenting to have moved, where it's going to be moved, and for what purpose, who's going to see it. And it has to be freely given, as you said, so they can't be coerced, especially in the employee context. But obviously, when you have 20 custodians in Europe and you need to move some of their emails to the U.S. for litigation, and especially when they're not, their job's not on the line or anything, it's just for purposes of litigation. The emails are generally not really personal information of theirs. That is a mechanism that is, everyone should do that. It should be on their checklist because it's the easiest approach. There's also another derogation or exception for legal claims, for defensive legal claims. And the Article 29 Working Party has talked about that a little bit. But it really depends on the context of the case. So if you have a litigation in the U.S. over some corporate dispute and the employee has some personal information that happens to be on their computer and their emails, and it's really not at all relevant to the case, then it may be hard to justify why that information is getting moved into the U.S. So doing the bulk transfer, you collect and then you move it to the U.S. for review and processing, it might be hard to make a case for it. On the other hand, you may have a legal dispute with that employee, and the dispute happens to be taking place in the U.S., but there are claims against and from the employee, and there it might actually be very justified why their personal information is getting moved into the U.S. dispute. And so there's really a spectrum there.
Yeah, and I suppose one of the other challenges to consent is not so much the discovery domain, but perhaps when you start looking at regulatory investigations, if you're investing someone for alleged fraud or bribery under the FCPA, for example, it's pretty hard to get consent of an alleged perpetrator, I would imagine. So there's some circumstances where consent might pose a problem. David, one of the other major areas of difficulty people are having in terms of data being moved from the EU is the blocking statutes, and we had a bit of a chat about that the other day. You might like to give us a bit of an overview of your perspective on that and some of the US case law, perhaps.
Yeah. Well, first thing to note is that all of this, as you can tell just from what we've heard so far, is very complicated in terms of moving data for discovery purposes. And I've been trying to understand it for 5 or 10 years now. And what it all comes down to put it very simply, is there is no way to move data from Europe to the US for litigation and comply with the rules of Europe and the US. Period, full stop. That's what it all boils down to. Now, you can hear people talk about safe harbor, binding corporate resolutions, model contractual clauses, consent. None of that works. You've heard a few reasons why consent doesn't work already. Let me give you a couple more. You've got to get consent not only the custodian, but everyone whose personal information is there. Personal information is defined incredibly broadly in Europe to include anything that allows you to identify anyone. So think about the emails you have. They don't just contain your personal information, they contain personal information from everyone who ever wrote to you. You can't get their consent. And this whole idea of coercion, it's not that the employee actually has to coerce somebody, it's just presumed that there's a coercive relationship if the employer asks for the employee's consent. Beyond that, under the consent rules, the employee has to have the right to review all the data for accuracy before it goes. The employee has to have the right and ability to withdraw their consent. It just doesn't work. And none of these things work because even model contractual clauses and binding corporate resolutions, you can't really comply with them for litigation where the data is going to get out there. So the bottom line is what you try to do is you comply as best you can and hope that if there's any enforcement action, which there hasn't been, there's been almost none, although there's talk about enforcement increasing. So you try to comply as much as you possible. Getting consent's better than not getting consent. Having model contractual clauses is better than not. So you try to do your best. But you're going to have an even harder time if the data is from certain countries with blocking statutes like France, Germany, Switzerland, which essentially say it is a criminal act to take data from France to use for U.S. litigation. That's a criminal violation. Now, there may only be one case where they've ever tried to enforce that, but that's what the rules say. So you're really in a difficult position, and the best thing to do from the U.S. litigation perspective is to push back on any discovery request seeking international information, try to avoid it, and if you're forced to give data, try to do as much data minimization as you can in Europe, narrow down to what you really need. There's other alternatives, there's cases, there's the Hague Convention, but nothing works well.
And I think there's an opportunity with what Dave is saying, because they're just revising the federal rules now, so if you're an eDiscovery person, you know about that. And so proportionality has come to the fore in 26B1. And you got a bunch of judges who are very cognizant that there's a big privacy issue over in Europe. So this may be our moment to teach the judiciary that you should push European data to a slower track, or to a track where you give it the time to get the privacy consents, understand we might not get them, and just it's an educational opportunity. Maybe it's a teaching moment for the court with this new proportionality emphasis in the rules.
So we're between a rock and a hard place. Or, as I said once, quite embarrassingly, I'm between a chicken and a hard egg. I get my metaphors mixed up. But it is a bit of a wing and a prayer, isn't it? It looks as though there's no safe passage, really, for data that is going to entirely protect our clients.
Worse bad.
I mean, we've had cases where we just had to do a production. For example, in Switzerland, there are Swiss banking laws, and there's just no way around them. And at the end of the day, it's if you want to see these documents, you have to come to Switzerland. And under very strict circumstances, regulators or parties in a dispute will be allowed to look at certain materials in Switzerland, and they will never leave that country. And so, that just may be necessary.
Melinda, did you want to talk? Actually, I should ask David before we go off the case, or are there any of those cases we spoke about the other day that you'd like to highlight? We've got a few here, and I know we're running out of time.
But I could give you a quick on, we talked about 4 cases. So
sure.
The first case is Air Special, which was the U.S. Supreme Court case back in '87. Basically said international comedy should be respected, but the Hague Convention is not the only way to get discovery. That was a case of a plane crash in Iowa. A French company manufactured the plane parts. The plaintiff sought discovery from France. The defendant said, well, you have to go under the Hague Convention. And the U.S. Supreme Court said, no, that you could use the Hague Convention, but that's not the exclusive way to get data. And we look at these various factors from the third restatement of foreign relations law in determining when we're going to allow international discovery, the importance of the issues, the specificity of the request, the origin of the data, did it come from the U.S., availability of alternatives for the data, and the weight of the national interest in conflict. So that's the '87 case that all other U.S. authorities since then has cited. We just talked about 3 other cases. True Positions was a case in the Eastern District of Pennsylvania in 2012. And it was an antitrust case where the defendant was trying to avoid discovery based on the French laws, data privacy laws. And Judge Kelly in that case said that France has never enforced these laws, and there's a strong interest here. So Judge Kelly ruled in favor of allowing the discovery. It was limited discovery, jurisdictional discovery about an important antitrust issue. And so that discovery was allowed. More recently, there have been 2 cases that are somewhat important in 2014. One that I found very interesting was the Microsoft Credit Corp versus Uzon case, where Microsoft had been defrauded out of about $2 billion by a company that had borrowed money and then was misusing it, and was these folks, the Uzons, were essentially fugitives both in Turkey and in the U.S., and they were hiding assets in a bunch of shell companies with bank accounts all over. Motorola subpoenaed various banks all over the world to get information about where these assets were hidden. And Judge Rakoff did sort of a country-by-country analysis of how much these countries enforced their privacy rights, and basically said in France, in Jordan, in the UAE, they really haven't done much enforcement. However, in Switzerland, they've demonstrated a strong national interest in privacy, and they really enforce their privacy laws. Therefore, I'm going to quash the subpoena in Switzerland, but I'm going to insist on enforcement in France, Jordan, and the UAE. And then the final case, very briefly, that's of interest because it's being decided right now, Microsoft versus U.S. The DOJ had a criminal search warrant served on Microsoft to essentially get the email account of one individual, and most of that content was available in Ireland, not in the U.S. Microsoft refused to produce the information from Ireland. Judge Francis, finding that the interests in disclosure outweighed the privacy interests, ordered the disclosure, and that was appealed to the Second Circuit. That was just argued on September 9th, and now we're all waiting to see where the Second Circuit comes out, and their decision is expected anytime in the next couple of months. So that's a quick summary of some of the case law we've seen.
Thank you. That's great. Melinda, I wonder if you could possibly give us more the legislative reform side of things and talk a little bit about privacy reform as it stands in the US as a response to this or concurrent with these international developments.
Sure. So there's a federal law that just passed the House called the Judicial Redress Act, which would give Europeans, it's not just European, but citizens of countries that are designated by the Attorney General, and it's imagined that'll be European countries, the same rights as American citizens under the Privacy Act of 1974, which means that they would have an ability to challenge US government access to their data. And this is considered sort of a prerequisite to any possible US Safe Harbor 2.0, and it was seen as, was hailed as it's great that it's passed or that it's going through. I think it might pass and get signed into law, but there's some fundamental questions about whether it's actually going to serve the purpose that the Europeans want, because it will exempt certain agencies from accessing the data. The countries could be taken off the list at any time, so the Attorney General could say, yes, French citizens, you have the right, and then they could revoke that right at some point. So it's not a perfect solution, but it is seen as a first step and a necessary first step to negotiating Safe Harbor 2.0. And then, as we were talking about, the CISA is kind of complicating things in that sense. And in terms of other legislative efforts, such as the Judicial Redress Act, I'm not aware of any at the federal level. But as you and I were talking about the other day, California recently passed this very comprehensive Electronic Communications Protection Act that makes it really the best in the country in terms of protecting people's data, almost on a European level. And I was joking with a colleague at that time, well, maybe California will get an adequacy decision by itself, and it'll be an island in the United States, and you could transfer data just to California. But it's, it's not impossible that could happen, because California is moving forward with these kinds of European-style privacy.
Well, that's where a lot of the data resides, isn't it, in Silicon Valley?
And where does it reside? That's there's questions about that.
Another
but
question,
to the extent that the Europeans choose countries or jurisdictions that they deem adequate, they could conceivably deem California adequate, whereas not the rest of the United States.
So California could be the new safe harbor.
Yeah, probably not going to happen, but it's not impossible. And they also recently, the Attorney General of California, who's very proactive in the privacy space, did an enforcement action against a company for recording telephone calls, really basic privacy violation. But in her order said you have to appoint a chief privacy officer. It doesn't have to have that title, but someone who is responsible for making sure that you're complying with privacy laws. That is very similar to the EU requirements that you have a data protection officer for companies that have more than 50 employees, but there's no other requirement in the United States that you have a chief privacy officer. So California is moving in a European kind of direction and might push the rest of the country that way. We'll see.
Damien, I wonder if you could give us a perspective on the advice you would give to a large multinational, or what do you think large multinationals should be doing in the wake of Schrems? What are the important things that you think they should be looking at if they've got transatlantic data issues?
They probably want to look at the list of safe harbour accredited companies as a starter, and then go through that list and find out any of those companies that are working within that large multinational.
Okay.
And then for each one of those companies that are, then drop down to the different levels of alternative means to move the data. So look at whether or not you have put in place internal transfer agreements or agreements with external parties under the standard contractual clauses that the
Right.
European Union has approved, the binding corporate rules that Pat's mentioned, the consents, the other derogations, like that it's for a legal claim, but bearing in mind that all of those derogations are very narrowly construed within Europe. You know, they look hard at people who have to fall back on derogations. I mean, any multinational company has got other options, which are, for example, to look at the data in detail before it needs to go anywhere, and then look at redaction, right? It's personal data, that's the concern. So, you know, if it's 10 documents, then I could look at it and say, well, I'll just redact that, and that, and I now have a set of documents that could go because it's not got any personal data in it. That's a very simplistic 10 documents in front of one person. You know, with the powerful analytics tools, you know, we've just heard next door about the wonders of predictive coding and the sort of intelligent algorithms that exist and computers thinking or not. You know, those tools offer opportunities for a company that needs to move data to look in terms of whether it can anonymize the data so that the risk of being in breach is a lesser risk. I mean, the Swiss banking secrecy laws, there's a sort of and these other blocking statutes are troublesome. The sort of irony is that if you are compelled to produce the data, let's say a US court issues a subpoena that is regarded as being compulsion, then you can't do it, right? So that's the banking secrecy law. But if you do it voluntarily before the sort of before the seal's put on an order that is regarded as compulsion, then you could do it suitably anonymized, right? So move quickly, assess what it is, how quickly things need to be there, look at your options, work out whether or not it's compulsion, right? What's the point at which you those blocking statutes kick in? I don't think that the fact that there's been decisions in the past about blocking statutes, I mean, you know, I've always found those decisions strange ones really when one country judges another country's laws and says, listen, you know, we don't think you're really going to enforce that. It's like, well, thanks very much. You know, what's it going to do with you? They're my laws, not yours. So, you know, your opinion as to like whether I'm going to enforce my laws is like, you know, it's like candle in the wind. It's sort of, you know, fine. So I've always found those decisions very interesting, in particular that Microsoft one, where there's like a sort of, you know, side-by-side analysis. Like you go on the iTunes store, or, you know, you buy an iPad and you can compare 3 different iPads and go like, oh, that's got processor. You can compare Jordan and France and whatever, and then go like, you know, those two, you know, come on, and away you go. And it's like, well, what about the people in Jordan? Or, you know, or France, who sort of think they've got rules that are there for a purpose. So, you know, I find those decisions generally very interesting from a sort of European perspective. And, you know, then generally the kind of, you know, so I've sat and I've talked with US judges on panels, you know, not dissimilar, not as sort of attractive as this one, but not dissimilar, where they will say we do pay heed to other people's laws, the comity, the sort of, you know, that you should, the Sedona principles that exist out there that say, you know, be reasonable, be proportionate, be sort of understanding and loving in your response to things. And, you know, those principles, right, which are just basically saying respect, that's the kind of, you could sum up in respect, that's the word. You know, the judges will say they do that, but at the end of the day, those judges, you know, it's in the end you've got to make a decision, right? You can have respect up to a certain point, but then you've got to say, what am I going to do? What's the chances that a judge is going to, in the end, say, well, you know, my respect has led me to weigh on the side of I'm not going to allow you to get that data. Right? You know, it can happen, but so can lots of things. I wouldn't be that convinced. Was that the question you asked?
Not really. But you were doing well. Patrick, we've had a few chats over
See
time.
if I can do better, Damien.
Yeah, I'll throw one at you, and feel free to say whatever you like in response. We've had a few chats about the notion of actually doing projects in the EU, at least from a discovery perspective and litigation.
Damien, and he was kind of saying that, and you know, if you were an American who wanted to respect the laws over there, and try to go with their concerns and meet them, you wouldn't move a lot of data over to the States. You would do all the sorting out of the data in Europe, and you would, you know, hopefully if in Germany, where they're especially sensitive about it and they're covering up, they're putting pieces of tape on their cameras and all that kind of stuff, you say, hey, you know, all we're going to do is we're going to bring it down the hallway, and you know, Joe Sherman's got her software set up there, or whoever it is, folks here, you know, you can get these mobile kind of setups, and you know, we're going to do a lot of really good analytics, so we're going to cull it down to the smallest amount we can. If you could possibly have reviewers that, you know, really, if we really cared, we'd go to Europe more, and just make it so you don't have to move the data here. And cull it down to the smallest amount that you can, and then literally show them the emails or documents, you know, per custodian. You know, these are them, you know, and they may become public over there, you know. So and get the best kind of consent you can. I don't know that a data protection authority would have a hard time with that if it was fully explained. But when we just grab people's emails and bring them over here and throw them into the review machine, I don't blame people for having a problem.
And I suppose there's a difference between the concept of an incident like litigation or an investigation, which requires one approach, as compared with business as usual data transfers within a large multinational where they're managing consumer data and employee data.
Well, I think if you're looking for bad guy stuff, you're not going to necessarily want to be getting consent. So you're going to, I mean, you're not allowed to process and collect it over there anyhow. But let's say you do, you may, if you're doing an investigation, it might be wise to keep it in situ as much as possible, because you're not going to get consent, and then kind of work from there.
Sure.
Would be my impression.
Sure. Melinda, did you have any comments on that? I think you
Well, I don't litigate and I don't do eDiscovery. I'm 100% privacy and data protection lawyer, and so after I go through all the other concerns of business as usual data transfers, at the end I'll say, and by the way, if you get sued, you're going to have a bunch of problems transferring your data as well. And so, like, this whole world is aside from the basic, just I want to run my business. I have employees in France, I have employees in England. We're trying to do payroll, we're trying to evaluate who to transfer where. They're not allowed to send their data either. Now, in a litigation context, it's more contentious and the stakes might be higher, but just day-to-day business operations with this safe harbor decision, some companies are asking, am I even allowed to run my HR department anymore? And I have clients that are looking to put operations on the ground in Europe to do all their HR over there, so no HR data goes to the United States. And aside from HR data, there's customer data. Multinational corporations, besides Google, but even just, you know, large brands, like luxury brands that have clients that are in multiple countries, they can't, technically they're not supposed to transfer the data to the United States. They registered for the safe harbor so they could do it, and now they can't. And that data is in the United States now, so what are they supposed to do about it? These are, you know, broader concerns even than just in this specific litigation context.
And there's certainly more than one commentator saying that there's going to be a bit of growth in the EU information tech business as a result of all of this. There's been a lot of investment in data centres in the EU by many companies in the last, even in the last month. So,
I mean, no one in the EU was saying we're doing a data localization requirement like they've done in Russia, where you have to have the data in Russia. But this safe harbor decision is a backdoor data localization requirement to some extent. They're saying, well, you know, you could try to do BCRs or model clauses, and maybe the Germans will say that you're not allowed to use them because they decide that it's not okay. So, but you could try that, or you could wait for 2.0. We could just, you know, set up operations in Germany. That'd be a lot easier, wouldn't it, if you just hired a bunch of Germans to do this for you? And so it's kind of a one way to get a data localization requirement without calling it a data localization requirement.
Well, I think one thing that is very clear is that there's no clear-cut answers in all of this. It's going to be a very interesting domain for us to all watch. We're all impacted, whether we're involved in day-to-day litigation, investigations, or just advising corporate clients in relation to privacy and information governance. And I thank you very much for coming today, making the trip. My goodness, it was like one of those Eddie Chase sort of movies, getting you here, Damien, the planes, trains and automobiles to get you over from London. But we finally made it, and he's awake and fully charged up with energy today. So thanks for the effort, and thank you to everyone else for coming. I should ask, any questions? Good luck with the questions, because it's, I'm sure everyone's got lots of questions, but where do you start with this? Yes.
One, I don't recall who said it, but we're talking about it that this is applicable to all EU residents. Is that true, or is it EU citizens?
It would. I mean, it would be the. It's a very good question, Pat. Is this your?
Actually,
I would say it's. I mean,
I've seen it enforced as though it was all residents.
The geographical
Yeah.
position.
Like
is
an
the-
American living in France,
Yeah.
their data is protected by French data. You know, how that plays out in terms of actual enforcement is a different story, but.
and I think it does also cover EU citizens abroad as well.
Like, if I got asked this question recently,